We are live. We are live. Hello, 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 hello. Mic check. We are live. We are live. Hello, 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 hello. Mic check. We are live. Hello, 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 hello. All right, I'm gonna play a little song before we. So today I just want to talk about the Alex Baldwin trial. As many of you may have seen all over the news, the charges have been dismissed. His case for involuntary manslaughter has been entirely dismissed. And I just want to talk about the legal concepts that resulted in this case being dismissed. Um, Obviously, or allegedly, the prosecutor committed what's called Brady violations. So let's do a little legal education here. We're going to talk about Brady, Giglio, and what those cases mean, and how those cases resulted in a dismissal in this case. So let's talk about Brady. What's the Brady rule? Brady v. Maryland was a 1963 case that went to the U.S. Supreme Court, and the court ruled or determined that the prosecutor must disclose any exculpatory evidence to the defense. So, what is exculpatory evidence? Exculpatory evidence is evidence that would tend to suggest the defendant is innocent or the defendant's criminal culpability is lower than what he's accused of. So, any evidence, exculpatory evidence, is simply evidence that could potentially help the defendant. If the prosecutor has any such evidence, they're required by law to turn it over. It's the fair thing to do. The absolute worst thing that can happen and does happen in our criminal justice system is innocent people going to prison. And a major cause of that is evidence either not being collected, whether intentional or unintentional, or evidence being hidden, which clearly in this Baldwin case was intentional. And honestly, folks, it happens more times than we could imagine. So let's and then let's define exculpatory evidence. Evidence that may be favorable to the defendant, potentially proving innocence or mitigating the severity of the offense. Just what I said. The consequences of a violation. A violation of the Brady rule can result in reversal of a conviction or a new trial, or in extreme cases, as in Mr. Baldwin's case, a dismissal and with prejudice. So his charges were dismissed with prejudice, means double jeopardy attaches, which means they cannot bring those charges against him again. The case is over. There's no retrial, new trial next year, next month, as far as the criminal case goes. Now they can still sue him civilly. The young lady that unfortunately lost her life, her family can still bring a civil suit for money against Alec Baldwin, which I believe they will do if they haven't already done so. And oftentimes the civil case kind of sit back and wait and see what's going to happen in the criminal case before deciding what course of action to take in the civil case. So let's continue on, and we covered Brady. Now let's talk about Giglio. This came out about 9 years after Brady. Brady was 1963, and Giglio was 1972. It's a closely related to Brady. That's why you always hear these two Supreme Court cases referenced together. So what does Giglio say? Prosecutors must disclose any information that could impeach the credibility of a government witness. So in a case like, all this simply means is the witnesses against the defendant, if there's something that the prosecutors have or aware of or know about that shows that this person is not necessarily credible or trustworthy, or their testimony shouldn't be relied on in the blank. Like if there's reason to doubt the credibility of a witness and the prosecutor has something showing that, then they're required to. They're required to turn it over. All right, looks like I got a guest trying to join. I'm gonna bring you on, Mr. Spears. Can you hear me?
Yeah, I can hear you, man. How's it going?
It's going good. You got questions? You just want to check in?
Yeah, I wanted to see what you was talking about.
Just right now, I'm just talking about this Alec Baldwin case and some of the Supreme Court precedent that the case deals with. Brady violations, Giglio, and so Brady is basically a Supreme Court case that requires the prosecutors to turn over exculpatory evidence. So exculpatory evidence is simply evidence that tends to show that the defendant is innocent, or it tends to show that the defendant's criminal liability or culpability is less than what the prosecutor is alleging. So they're just required to turn this stuff over. They didn't turn it over in the Alec Baldwin case. It happens all the time in everyday cases. We don't hear about it because it's not high profile like these celebrity cases. But it happens to people every day. It's really up to the lawyers to dig to find what's not there. So like for example, in the typical criminal case, we file what's called a discovery motion, and they're required to send us all of the evidence they have that could be potentially relevant or Brady. And we almost never get it all. So I tell my clients, the first thing I do when I get 500 pages of discovery is I organize it by documents, then I number it, or we call it bait stamp, and then I go through it. So I'm going through it in a review and discovery, but I'm always looking for what's not there. Because you'll read and they'll reference there was a body cam footage or another officer wrote a report, and you'll go through all the documents that have been turned over, and you'll notice that, hey, you said this doctor had a report also. However, I do not have a copy of his report. When can I get it? I need it.
Right. So is that still legal for them to do that? So they could choose not to send you all the evidence, and it still be legal and the judge can be okay with that, or if they does do something like that, are you able to or file and say, hey, well, they wasn't honest about turning over all the evidence at first. I don't want this to continue to happen. Then what process would you take to, alleviate that?
So what happens a lot of times is initially you'll have the prosecutor will give you the evidence, and he or she will say, well, I don't have that report you're asking for. The police didn't give it to me. Well, that sounds nice, but that's not a legitimate excuse, because the law says the government is required to turn over everything they have. Now, so what does that mean? That means that the government is the government. That's the prosecutor as well as the law enforcement agency that's investigating the case. So they're all considered the state or the government, and they have to turn it over. It's the prosecutor. The prosecutor has an obligation to request something that's not in their file. Like if the police didn't turn over a body cam, or if the police didn't turn over some forensic evidence, DNA evidence, they're required
Right.
to ask for it. And so a lot of times they don't ask for it. I'll just say because I don't, a lot of times they don't review the file as thoroughly as a criminal defense lawyer who takes his job seriously does. So a lot of times I'll make a checklist and say, look, I got these 10 things. I know they must exist. They're referenced in these other documents, but where are they? And then they'll go, oh, okay, I'll go to the police and get it. Most prosecutors are not trying to intentionally hide anything. I don't think that happens a lot, but it does happen. But I'll tell you what I do believe happens a lot is that a lot of the evidence is not received by the defense because the lawyer simply doesn't look and doesn't ask for it and doesn't demand that it be turned over. But as we see in the Alec Baldwin case, sometimes there's no way for you to know if a prosecutor wants to violate the law. Sometimes you don't find out until after trials. A lot of people go to prison and spend many years in prison, and the stuff isn't discovered until they're fighting through the appellate process.
So I got another quick question then. So say that you did file for, all the evidence like you said, and they did miss something. And I read right here that says that you can eventually reopen that case, right? if you find some evidence that could have maybe convinced the jury that, hey, this was a key piece of evidence that got left out. If somebody get convicted and then you find out that you had a key piece of evidence that was left out, do you have to then file to reopen that case under something different, or can you open it under the same thing since that evidence was found now?
So every state is going to be a little different, but it's typically going to depend on the time frame. So, like for instance, if somebody's convicted here, they have to in Louisiana they have to file an appeal within 2 years. After that, they have what's called post conviction relief. So, for instance, if somebody's given 20 years and the new evidence or evidence that shows their actual innocence isn't discovered until 5, 10, 15, 20 years down the road, then they have to turn around and try to file an application for post-conviction relief and try to get the conviction overturned or at least get a new trial or something, some kind of relief. But the time, a lot of times these people lose time that they can never get back, and that's not to be discounted.
Right, right. And with the Alec Baldwin case, wasn't it like a prop gun or something like that? I kind of followed it a little bit. Wasn't it a prop gun that had a a live round in it that
Yeah,
killed
there
somebody?
was it was the movie. They were shooting a movie, and they what happened was they were supposed to have all blanks, but they borrowed some blanks from the movie 1883, and what they learned was that some of the ammo used in that movie was live ammo. They didn't use the live ammo in the movie 1883, but when they were training the actors of 1883, they were trying to familiarize them with how it feels to fire an actual firearm to understand the recoil, so it'll look realistically, I guess, in the show. So anyway, they got some of that ammo, and somehow some of the live ammo got mixed in with the dummy ammo, and that's how the lady got shot.
And she's deceased now, right?
Yeah,
Or
two
is she?
people were shot. Two people were shot. One passed away, and the lady passed away, and the gentleman, he's fine.
Right, right. Okay.
More questions? Or you want me to go through?
No, you can keep on. I mean, I just because like it's so much going on right now with everything that's going on. I kind of was looking at that, and then other stuff that's headlining right now that everybody probably been seeing. So I kind of been following a few things, So not that as closely as some of the others, but
The Lord, you talking about the YSL trial that a lot of people been.
a fire sale trial. You know, the shooting at that that happened a couple of days with the president or whatever. Just a lot of stuff like that. You know, just been kind of paying attention to. Um, Also, I was listening to something about if you can explain it to me a little bit better. But I did hear something about the Supreme Court overturning something with Trump or whatever. Uh, uh, I mean, I guess I'm asking, could you explain it a little bit better to me? I heard it a little bit on the Breakfast Club the other day. They were saying that the Supreme Court made it to where they can overrule a conviction for a president, and what does that mean? Is
I'm,
that
I'm
you know?
I actually haven't seen it, so I haven't looked at it or been familiar with it.
Right,
I can't even tell you what. I
right.
will look it up though, because there may be
Yeah,
something I need to.
that's one thing I wanted to ask you about because they basically was saying that now that it's taking the power away from the people and basically the Supreme Court is able to choose and exonerate a conviction from a president and basically giving them the power to do whatever.
Well, you know that the Supreme Court can overturn anybody's conviction.
Right, right.
So whatever grounds, that's how a new law is created. That's how unfair laws are struck down. Sometimes the Supreme Court has to intervene, and they do quite often. So I would say they can do that for anybody.
Yeah, okay. No, yeah, you can go ahead and continue, man. I was just, if I had a few questions or whatever.
All right. So what was our Giglio? So and then basically failure to the consequences for violating Giglio can lead to a reversal of a conviction if it's found that the evidence could have affected the outcome of the trial. And the same is true for Brady. So here are the key differences between Brady and Giglio. Brady covers all exculpatory evidence, while Giglio specifically pertains to information that affects a witness' credibility. Brady focuses on the defendant's guilt or innocence. Giglio focuses on the reliability of testimony. So the reason, and these rules exist for a reason, and here it is. It ensures fairness in trials by providing the defense with crucial information. And it helps maintain the integrity of the judicial system by preventing wrongful convictions. So if you think about it, these rules are certainly needed because the truth is that when somebody's being charged and investigated for a crime, the most the prosecutor has tons of support. The prosecutor has the state, the police agency or agencies that are involved to assist them. The prosecutor has unlimited resources. Typically, a defendant has a one-man show, his defense attorney, and we typically have people assisting us, law clerks, investigators, but it's nowhere near the capability that the state or the federal government has if somebody's under a criminal indictment. So this rule is the only thing that even gives us a chance to have some fairness in our justice system. So when it's violated, it's just problematic. I'd say it's a major way innocent people end up in prison. So so I want to do now. I really want to go through and discuss these the videos. The videos. It's just 3 videos I pulled from that Baldwin case. So the first one I want to go through is this. This was the prosecutor. They brought in a special prosecutor, and she actually resigned during the trial, right before it was dismissed because she didn't like what was done. So I'm gonna go ahead and hit play, and let's check this out together.
So, want to hear how crazy this got? One of the lead prosecutors, not the one who took the stand, Morrissey, the one who gave the opening statement, quit today. Why? Guess what? This almost never happens. This prosecutor wants to be heard enough that she's coming on TV right after this happened. Erlinda Ocampo Johnson joins us now. Thank you so much for taking the opportunity.
Hi, Chris.
First, let me give you a chance to respond what was said about you. Another member of the team said you left the team because you didn't like that this Brady hearing was public.
Absolutely not. Absolutely not. I left because I learned about this evidence when the public learned about it yesterday, late afternoon. As I don't know if you're aware, I actually came on this case kind of late in the game. I came on the case towards the end of April, so I had to get up to speed. I was not involved in the Hannah Gutierrez case at all. And so I was not aware that this individual had taken this ammunition to the sheriff's department and provided it to the officers. I learned all of that yesterday when Mr. Spiro was cross-examining the crime scene technician. So I inquired some more. And this morning, when the motion hearing began, my position was during the lunch hour, before the lunch hour, during the lunch hour, we have an obligation as prosecutors. We have an obligation not only to the people, but to the defendant. Mm-hmm. And our obligation is to make sure that all the evidence is turned over. We don't get to decide what the defense is going to be. Our job is to ensure transparency and to ensure that the defendant has everything that the prosecution has gathered.
So she hits the nail on the head. We can't have prosecutors cherry picking what should be turned over, what's Brady, what's not Brady. At a minimum, they can ask the judge to do what's called an in-camera inspection. If they're not sure if something should be turned over or not, they can ask the judge to look at it and decide if it should be given to the defense. But for a prosecutor to not turn over something, which in this case it was ammo. Somebody was shot and there was additional ammo turned in and she chose not to turn it over. To me, that's clearly a Brady violation. She couldn't have realistically, legitimately thought that this evidence shouldn't have been turned over. And truth be told, if it was unrelated to the case, why not just turn it over? Because she could object to at trial. Any evidence that's not relevant, you can always object to it. So her not turning it over is just a problem. So let's see what else this prosecutor has to say. You got any questions, any thoughts on that? What you've heard from her so far?
No.
What they do with it, that's up to them. Go ahead.
Two things. One,
sure.
The better minds that I bring on the show, because what do I know, were very impressed by your opening. They felt that you had good command and that you made a very strong case. Did you believe that Alec Baldwin should be found guilty?
I did. I believed the evidence that we had. I had no idea that there was this other evidence that had not been turned over. That there were some actions that were done during the filming, and there was some recklessness. I did based on the evidence that was available. But my job is not to get a conviction, it's to put the evidence before a jury. That's how I saw my job, is to put all this evidence before the jury and let the jury decide. But once things start, go ahead.
No, I want to hear you. But once things what?
So once I learned that this evidence was not turned over, that it was there, it was under a different case number, and my obligations, my ethical obligations as a prosecutor. Now, keep in mind, I've been a prosecutor. I was a state and federal prosecutor for over a decade. I've been a prosecutor. I've been a criminal defense lawyer for the last 16 years. So I've been on both sides. And I know what you're required to do. And when this came to light, I think that the best decision would have been for the state to dismiss the case. That's why I resigned.
Really?
Because I believed that case should have been dismissed. And I advocated for that over the lunch hour. And it wasn't. And so when we came back after the lunch hour, I asked to withdraw.
So you wanted the prosecution team to walk away from the case. They said no. So you said, then I'm walking away. And then the judge basically agreed with you. So I have two questions. First one is, So you believe it should be dismissed? Explain to people who don't understand anything about the law, why did you believe this ammunition was so important for the defense?
So obviously, you're a lawyer, I think. Brady versus Maryland imposes requirement on the prosecution to turn over evidence. The rules of criminal procedure impose those requirements, those duties as well. So is the evidence material? That's number one. How timely is the disclosure? Without question, this was grossly untimely.
Ah, yes, I love the sound of my money being wasted. Who the heck likes that? I don't know about you, but the only way to cut down on costs these days is to cut down on your bills. Everyone is getting subscriptions and doing.
Number two is the material. So the question is, could the defense have made some use of this evidence in their defense? And like I said, we as prosecutors do not get to make that decision what the defense is going to be. It's, can the defense use this, and could it potentially raise some sort of reasonable doubt? And you have to step back. You're not an advocate. As a prosecutor, you're not an advocate. You are there to present the facts and to present the evidence. And your job is, and that's why I took this case on. I agreed to come on board, is because there was a woman who was killed. No question about it. This was tragic. And something happened. And a jury needed to make that decision. And so I believe in the system. And unfortunately, something went horribly wrong here, and I was not aware of it. And when I did become aware of it, my ethical obligations dictated that I advocate for a dismissal.
You hear her talking a lot about her. This prosecutor basically did exactly what needed to be done. She saw that a Brady violation had occurred. She thought the appropriate remedy was to dismiss the case. Obviously, whoever was above her disagreed, so she withdrew. I mean, she has you hear her talking a lot about her ethical obligation, and what it is that she has an ethical obligation under the rules of professional responsibility, I believe, to report the other prosecutors. If she believed they intentionally hid evidence that should have been turned over, she has to file a complaint against them with the Bar Association in New Mexico. So, she appears to want to protect the integrity of our criminal justice system as well as protect her livelihood. If she partakes in it or knows about it and ignores it, she's subjecting herself to discipline. I believe this other prosecutor is certainly going to be disciplined. It may be a slap on the wrist, or it may be a suspension for a period of time from practicing law. But something has to be done. Like I've said multiple times, this is how innocent people end up in prison. So let's see what else she has to say.
So let's talk about what went wrong, okay? And you guys at home can Google Brady versus Maryland. It's a 1963 case that basically just goes to things that either could be exculpatory, meaning it's evidence that the defense could use to show it wasn't them, or what they call impeachment, which is evidence that the defense could use to show that one of the witnesses for the prosecution is full of it, okay? Basically, that's what Brady was. They call it Brady material. Your co-counsel says you have it wrong, that this ammunition, she knew about it, obviously, and she says, nah, it didn't have any real value. It had no resemblance to the ammunition that is involved in Alec Baldwin's case. Why would I turn it over?
Well, at the end of the day, a jury could have believed that, but our obligations are to turn all evidence over that could potentially be used by the defense, their defense. It's not for us to decide what is the defense going to be. It's not for us to say, well, his defense was he didn't pull the trigger. So his defense
I got you, but here's the tough question. The suggestion, not from you, from me, is that this may have been in bad faith. Your co-counsel knew about this. She was willing to get on the stand, take the oath, and say, I see any value here. Defense counsel and you echo the same standard. You don't get to decide whether or not it has value. She says, yes, I do. Otherwise, how do I know what to turn over? And I thought this didn't meet the standard. What is the standard, and why do you believe co-counsel got it wrong?
Well, this is a lot to process. Obviously, I learned about this yesterday evening. But just in looking at, so the first time I look at this evidence was this morning because it was brought over to court. I think as you saw, the judge had them open the envelope. And so there were 3 rounds that looked very similar to the live rounds that were found on the set of Rust. Thinking as a defense attorney, I'm thinking the defense could have argued Hannah Gutierrez-Reed was a great armorer. She was completely competent, and there was sabotage. So you have that potential sabotage angle. So then at that point, potentially those 3 rounds do become potentially exculpatory. But the point is, it should have been turned over. It wasn't turned over. And
you think it met the standard? Any way you look at it, it should have been turned over. It was enough for you to step away. I want to ask you about the case now that it's dismissed, because I didn't understand why you guys brought it. I thought it was totally political. I thought if this guy's name wasn't Alec Baldwin, if it was Alec McIntosh, he wouldn't be there. That he pissed off the prosecutors early on by what he was saying, and they wanted to get him. Why am I wrong?
Well, first of all, I was not involved in the charging decisions. I will tell you that based on my evaluation of the evidence that I was privy to and that I saw when I came on board on this case, was that there were numerous clips from the filming on the set that showed that Mr. Baldwin, unfortunately, did engage in some horseplay.
This is how to get in shape fast.
This is your body. These balloons represent.
So, want to hear how crazy this got? One of the lead prosecutors, the one who took the stand, Morrissey, the one who gave the opening statement. But here's the tough question. The suggestion, not from you, from me, is that this may have been in bad faith. Your co-counsel knew about this. She was willing to get on the stand, take the oath, and say, I do. Otherwise, how do I know what to turn over?
The evidence was this morning because it was brought over to court. I think as you saw, the judge had them open the envelope. And so there were 3 rounds that looked very similar to the live rounds that were found on the set of Rust. Thinking as a defense attorney, I'm thinking the defense could have argued Hannah Gutierrez-Reed was a great armorer. She was completely competent, and there was sabotage. So you have that potential sabotage angle. So then at that point, potentially those 3 rounds do become potentially exculpatory. But the point is, it should have been turned over. It wasn't turned over. And
you think it met the standard? Any way you look at it, it should have been turned over. It was enough for you to step away. I want to ask you about the case now that it's dismissed, because I didn't understand why you guys brought it. I thought it was totally political. I thought if this guy's name wasn't Alec Baldwin, if it was Alec McIntosh, he wouldn't be there. That he pissed off the prosecutors early on by what he was saying, and they wanted to get him. Why am I wrong?
Well, first of all, I was not involved in the charging decisions. I will tell you that based on my evaluation of the evidence that I was privy to and that I saw when I came on board on this case, was that there were numerous clips from the filming on the set that showed that Mr. Baldwin, unfortunately, did engage in some horseplay with this gun. For example, one individual who was interviewed by the OSHA investigators and testified or gave an interview that there was a time that he allowed Mr. Baldwin to use him kind of as a target to shoot blanks at him as this person. And obviously, these are real guns. You don't do that with.
Can't hear you.
So I think that's enough on that video. I think what's ironic is that it appears they may have had enough evidence to get a conviction. But they were just being greedy. They were just trying to guarantee themselves a victory instead of applying the rules of law fairly. He was only charged with involuntary manslaughter, so they didn't have to show he did it on purpose or it was intentional, just that he was grossly negligent. And if he was harsh playing with a gun in any way, I think they probably could have met their burden to show that. But I think the prosecutor just got greedy and dirty and hid evidence, and now the man's free, as he should be based on her violation, and she is subject to discipline as she should be based on her actions. So, and the judge, Nick, you got anything you want to add? Any questions about what you've heard?
Yeah, so I was wondering because of like the question I brought up before, because now they have this new evidence that got brought forward. Is the are they able to charge him again under?
Nope, double jeopardy. So when the judge dismissed the case with prejudice, that means you can't bring it again. With prejudice means it's over. Without prejudice would mean they could bring it again. So the jeopardy attached when the jury had been sworn and they had called witnesses, so jeopardy attached. So it would double jeopardy. You can't be charged for the same crime twice, or your life and liberty can't be put on the line for the same offense twice. Now, that's not the same as a hung jury. If there's a hung jury, they can retry you because the jury didn't reach a decision. But if you go to trial and get found not guilty, or your case gets dismissed because of something the prosecutor did, then they can recharge you. Now, obviously, if you cases don't continue when a defendant doesn't show up or leaves in the middle of trial, disappears, typically they can actually continue the trial without the defendant, but even if they grant a continuance, then there's not going to be jeopardy attaching because the defendant doesn't get to cause the mistrial. But if the prosecutor causes it in an extreme situation like this, it's a mistrial and can be dismissed with prejudice. So recently, actually last month, the month before last, I had a trial, and it's a manslaughter case. So we're gonna have to retry it because the deceased gentleman's family screamed something out during jury selection. So had that happened later in trial, who knows what would have happened? But it was during jury selection. No jurors have been sworn to sit. No opening statements have been made. No witnesses have been called. It was the very beginning. An hour into the whole process, the judge granted a mistrial. I moved for a mistrial, and the judge granted it. So we have to go back later this year and retry the case. So let's see what the judge had to say in all of this. And give me a second. I'm gonna bring you back on.
Dismissal with prejudice is a very extreme sanction, and case law is very clear that because it's very extreme, I have to go through every single element, and I have to make a very good record as to why I'm seeing what I'm seeing. So, in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teskey gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense. Critically, the exculpatory value.
So you heard the judge. She said potentially exculpatory, and that's the rule. So the prosecutor said, "Oh, it's not exculpatory." Well, if we were to live in a world where it had to be all or nothing, it would be too easy for them not to disclose evidence that should be turned over. So it just has to be potentially exculpatory, which doesn't mean much. I mean, if it's a chance, it suggests innocence or a lower criminal responsibility, they should just turn it over. And they should have turned it over in this case. So let's see what else the judge says.
Value cannot be analyzed at such a late juncture because of the non-disclosure. Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper, State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state. Quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion.
The ancient Egyptians understood that they could use sound to reduce their weight and the gravity.
Or dismissal where the state's conduct is especially culpable, such as where evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, as pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case.
So what the judge is talking about here is that this is how we know this prosecutor is full of it. They logged, so whenever evidence is recovered from a crime scene, you're supposed to photograph it, bag it, tag it, put an item number on it, and reference it to the case. Well, in this case, they took that additional ammo and they put it under a different case ID. So it's not even related to the Alec Baldwin case. Now, there's only one reason they would do that I can think of, and that would be to hide it. Why wouldn't you label it as Baldwin shell casings 100 to 199 or whatever it was? You know, they just simply miscategorized it and logged it under another case, which is why the judge is highly upset. That's clearly intentional.
Agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong.
Double jeopardy. So you asked about double jeopardy, and you heard the judge say that the jury has been sworn. Double jeopardy has attached. That's it. They can't bring it back. So that's why she's going to dismiss it with prejudice.
Lesser sanctions. Under Harper, trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated, State v. Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial will not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The State has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has inherent power. Per State v. Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The State's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted. Now, with respect to the jury, I don't imagine you all want to return on Monday. I will take care of the jury.
Thank you.
We are in recess.
Hello, you can hear me?
Yeah. It's just kind of crazy to me that she showed like she was disappointed in what she was talking about, but he still got the case. I guess she didn't have any other choice.
The judge?
Yeah, right.
Yeah, I think the judge was very upset that this happened. She was extremely upset that this happened, but at the same time, she wanted to do the right thing, which she, in my opinion, she did the right thing. The charge needed to be dismissed based on what was happening. I mean, we may never know the truth. You know, the jury never. This is a case where the jury's never going to get to decide. But this is the prosecutor's fault. The prosecutor took that right away from the jury, and also took that away from the young lady who passed away. She took that away from her family, because they'll never get their quote unquote day in court because of this. So we have nobody to blame but the prosecutor for that.
Now, can the prosecutor be a lot of defendants now saying here? Can they now?
You cut out. Say that again.
Okay, so like the evidence did come out now. Can you understand me? Can you hear me?
You cut out again. Say it again.
All right. Since the evidence did come out, can a defendant now charge the prosecutor for withholding evidence?
So the prosecutors have what's called immunity, and it's almost complete immunity. You basically have to be able to prove they intentionally did something wrong. Even in this Baldwin case, I'd be surprised if this prosecutor was charged with a criminal offense. And it's probably even more or just as difficult for her to be, or her office to be sued in civil court for what they did. They have pretty broad immunity with respect to prosecuting people for crimes. That's in place so prosecutors aren't afraid to go out and do their job. But, I think there needs to be a limit. This is about as close to intentional as I've ever seen. I think it's blatant that she intentionally withheld this evidence.
Right. That's why That's why I asked that question, because you said that they got filed under a whole different case number. You know what I'm saying? Like that was intentionally hidden so they wouldn't be able to use it as evidence.
Right. Yeah, I think they intentionally hid it, but it knowing something is always a tricky thing. We got one more person trying to join us. Hold on. Well, hello there.
Hi.
Can you hear us with all that background noise you got?
I can. That's the waterfall.
Oh, well, don't go chasing waterfalls. Please stick to the rivers and streams that you used to.
Hi, Edmund.
What up, Reese?
I'm not sneaking on here, man. Hey.
Hey, he don't want to claim. You should be glad that man claim you.
You should be glad I claim you. That's
What's up?
that's true. What y'all talking about?
So you just chimed in. You don't know what's going on over here. We talking about the Alec Baldwin case. The case being dismissed for Brady violations. You know what Brady violations is?
Yeah.
They hid evidence they should have turned over. If you'd have been listening for the last 50 minutes, you'll know.
No, I ain't following that case.
Well, Alec Baldwin,
Pop up and
that case, what happened in Alec Baldwin case happens in cases all over the country all the time. It's typically people have to have the resources to discover it, or just a lawyer who's going to do their homework and demand that things that are apparently exist are turned over. Because rarely is everything turned over to a criminal defense lawyer at the beginning. You got to go through what they give you to figure out what's not there. And that's that.
well, I'm glad you can educate me. I was not following that case.
I'll do my best. It's not it's really not about his case. It's really about the fact that this happens all the time. But because he's a high profile celebrity, it's out there in the front. And look, he was looking at 18 months. So think about this. If they'll hide evidence in a case where somebody's looking at 18 months, what would they do in a case where somebody's looking at 18 years or life? Or somebody they think is bad and they want to get them?
Yeah.
So something needs to be done about it. Stuff is done about it all the time by lawyers and judges who refuse to accept that kind of behavior. So that's what happened in this case. I'm sure this prosecutor probably won't be prosecuting for a while, if ever. I think she should. I think she should lose her license. She's. I would imagine if this isn't the first time she's done that. People don't. It's pretty egregious what she did. So I'm sure she's done. I would. I would say she's probably done something similar, or maybe even on a smaller scale, but it's still unacceptable.
So what's gonna happen to her?
I think she'll be reported to the Bar Association in New Mexico. She'll have a disciplinary hearing. They can either suspend her permanently, suspend her for a time period, 1, 2, 3 years, make her reapply. They can just make her take classes to make sure she understands Brady and Giglio, which I'm sure she already does. Or they could just give her like a written reprimand. It'll be interesting to see if she gets fired, and if so, how quickly she gets hired somewhere else. I'm sure she'll get fired. I'm not sure she'll get fired. She may get fired, but then we'll see. I'm sure they'll circle back to it and see what happens to her legally for her actions. What's up? Anything else you want to talk about in this Baldwin case?
No, it must be. I literally didn't follow it.
Well, it was interesting, but what the most interesting thing is really what just happened. The fact that they tried to hide evidence. So, where you
I was
at?
distracted. I was distracted from the Donald Trump shooting.
Oh, we could talk about that.
Yeah, I
You don't
was
want to talk about
distracted.
that, huh?
Yeah, we can talk about it. I was just distracted from that mass shooting they had with Donald Trump.
You think that was real or staged? There's a lot of people that,
I, I think that was a Tyler Perry uh, plate. Tyler Perry set that up for him or something.
why do you think that?
I don't know. Huh?
Why do you think that?
I mean, I don't. The sniper on the roof is just so visible that people was recording him. It just it didn't look right. I feel like they just maybe picked somebody that was willing to be sacrificed for him and had him act like he was shooting them, and they shot him and he lost his life in return. Maybe they paid him or something ahead of time, paid his family or something. I don't know.
If they paid him, he won't get to spend it.
Huh?
If they paid him, he won't get to spend it.
No, he definitely won't. Maybe they paid his family or something. Or maybe they paid him ahead of time. He went and lived this life and then it happened. I don't know, but I don't think they was real.
What you think, Edmund?
No,
Oh,
I
nothing.
think it's
I feel like okay, in the midst of you being shot, you don't think of nothing else but to get up off the ground and throw your fist up to fight back. It's just a fun. Um, Election is in a few more months, so you know how connected it does get. So that's what I think.
What you think, Edmund?
I think it was real.
You
I
think
think
it
it
was
was
real?
real. I think it was real because it did have casualties. I mean, somebody got killed. I think for me, I don't think that I think that 20 kid might have had mental issues or something. You know what I'm saying? And I'm not, I'm definitely not picking sides, but sometimes you have people that you think are competent in their job that just ain't doing their job right. You know what I'm saying? So, um, with how many people seen him, on the roof with a gun, I think that even if they was pointed out to people that they could have thought it was some of their own person there. I don't know, you know what I'm saying? But I do think it was real, you know what I'm saying? I wouldn't I don't know. But you never know because there's gonna be a lot of opinions out there. Everybody, have their own opinion about what happened, but I just don't think that it was staged or anything. I think it was a real shooting.
I I think you would have to be absolutely crazy to stage a shooting. But I also think but I also think Donald Trump is pretty crazy.
Yeah,
Right.
So
he don't
But
mind.
so my
and that's
my
what I'm saying. Like for me to say, okay, I'm gonna stage somebody to try to accidentally shoot me. You know what I'm saying? If I was to try to stage some stuff like that and make it fake, it definitely wouldn't be no 20-year-old shooting at me. It's gonna be somebody that's it's gonna be somebody that's older that got more experience
yeah,
because
give me
a 20
a military
might
sniper who can
shoot
actually shoot the tip of
right,
my ear and
somebody.
nothing else.
Right. It ain't gonna be no 20-year old, you know.
So
That
I don't have an opinion on whether it's real or fake because uh, I'm a pawn just like everybody else. If it's
right,
real, I'll never know. If it's fake, I'll never know. And even if they come out with a report telling me it was real, I'm still gonna have doubt. If they come out with a report telling me it was fake, I'm still gonna have doubt. The
right,
Oh,
reality is,
Joe Biden sent the hit.
Yeah, we don't know. Joe Biden can't even he probably can't even hit the toilet when he take a piss.
Joe Biden sent the hit.
So
I just, like I said, I don't know what I don't know whether it's real or fake, but I do know that politicians can get nasty, especially when it's election time. So
I certainly got questions about the kid being on the roof and not being seen by the Secret Service. But who's to say, like Edmund said, who's to say the Secret Service just didn't miss it? Maybe we want to believe they don't miss anything. Maybe
Just because they service don't mean they're competent. You know what I'm saying? And they we would like to think that.
I mean,
You
look what they
know,
was with the Secret Service when they went to South America with Obama. They was with women instead of protecting the president. So who knows? Who knows why or how this happened? It happened. So whether it was real or fake, his reactions after the fact, it's hard to judge. It's hard to judge people based on how they react after something happens. Um, he might be like if when something bad happens, I don't panic. So when after the fact, the guy just might not panic. Like the shooting happened, it was over, and he was fine. Or he's batshit crazy. It's one of the two. But not everybody does. Like people expect people to freak out in situations, but we don't all freak out.
right? I was just, I'm glad you brought that up because I was just discussing that same fact with somebody at my job. That people they were showing videos like when the shooting was happening, like a woman videoing and not ducking down or whatever.
Exactly.
Everybody everybody reacts to a situation different. If you put 1,000 people in the room and somebody's going pull a gun, everybody's not going to always run. You're going to have some people in that room that's going to try to locate that gun to
Yeah,
see where the
somebody's
grip.
gonna run to him. Somebody's gonna run to him.
You're gonna have some people that's going to probably try to uh, rush that guy because if a group of people rush one person with a gun, yeah, you might take a couple of shots, but you also can disarm that person. So you got a whole bunch of people, depending on how much training they have, that's going to handle a situation differently. So when I see videos of people saying, "Oh, it was fake because this woman didn't even move; she was videoing," that woman just probably could have been, you know what I'm saying? One of those, I don't know what to call it, but just not aware. One of those people that's oblivious. Just didn't care. Wanted to get footage, and you seen people running. You seen, everybody's gonna always respond different, especially if you have training in situations like that, or if you maybe just not I don't know, aware person. Not really paying attention to what's going on. So yeah,
And we lost you.
it's not really surprising to me.
well, this all died down in November, whether it was real or not. We'll,
They'll
we'll be
find
long
out.
way in
They'll
November.
find out, and they'll release the documents in 100 years. But we'll all be gone. So
Right.
it won't matter.
Right.
What happened to Edmund? We lost him.
Yeah.
Oh, he fell off.
Anything can happen with election season.
Well, your uncle's gone. I think that's it. Anything else, Miss Kennedy?
No.
All right.
Just want to let the people know. Make sure you're ready to vote in the state of Louisiana.
This is
Local
not.
election,
This is
primary election. No, you said anything else, we talking about Trump. And
this is not
we
a
voting for the
political
president.
platform.
We voting for the president this election. So people need to go in and get ready to vote.
This
Okay?
is not a political platform.
But that's it. Is it raining down now?
I don't know. I'm about to go find out. I'm about to go see what we got to eat over here. I got a real cook over here.
Oh yeah.
Uh huh.
Everybody in the neighborhood. All right, well, I'm going back to what I was doing.
All right. Enjoy. Peace.
All right.
All right, people, that's all I'm going to talk about today. If you weren't able to catch the live stream, it's not too late to go on YouTube and subscribe to my YouTube channel. There it is, Great Elephant Law. You can follow me on Facebook, Instagram as well, TikTok. As I said, if you didn't watch the live and you watched the video and you got a topic you want me to discuss, just let me know and we will discuss it right here. My goal is every Wednesday night at 7:30. I am open to other nights based on what you guys think would be the ideal night to go live. Take care, folks. And here's a song for you before we shut it down.
In the courtroom's tall and bright, great elephant stands with might. Justice served both day and night. Great elephant in the light. Wears a suit that's always neat. Every client he will greet. Victory never feels defeat. Great elephant can't be beat. Great elephant fighting for the right. Great elephant shining so bright. When the battle strikes the wood, great elephant is only good. Wins the battles like he should. In the law he's understood. Always calm and always fair. In the courtroom with a stare. Great elephant does declare injustice won't be spared. Great elephant fighting for the right. Great elephant shining so bright.
Elephant stomping in the courtroom, great elephant defending the innocent, mind sharper than a tenement. Criminal defense game stronger than cement. Out here wrecking cases so your time may spent. Suits clean as the glass, arguments intense. Great elephant in the zone, watch him commence. Skipping past objections, mind so immense.